SOP Section 103-2 is SCBA. Revised date August 22, 2006. Beards will not be permitted to be worn by members of the CCFPD. Mustaches shall be. No beards or facial hair will be allowed by any CCFPD member. Mustache must be kept clean, trimmed at all times. Mustaches shall be permitted to extend 1/2 inch sideways of the corner of the mouth and 1/2 below each corner of the mouth. Handlebar style of mustaches shall be permitted, providing the mustache does not project or come in contact with the face piece. Fu Manchu mustaches, beards, goatees, mutton chops, and other eccentric styles of facial hair are prohibited. There is a grandfather clause that anyone who was currently a person of the CCFPD when these were written back in 1994 and in 2006 update were grandfathered. However, everyone else that is older than me is not grandfathered because I was the youngest member at that point in time. Sideburns may extend no further than to the bottom of the individual's earlobe, provided such extensions do not interfere with the proper seal of the face piece of our mask. Hair shall be kept neat and trimmed at all times. Individuals' hair shall not extend below the bottom of the shirt collar area. When involved in extinguishment of evolutions, members shall wear their protective hoods at all times. Protective hoods shall be worn properly, placed on the exterior of the face piece. Protective hoods shall never be placed underneath of the face piece. The SCBA shall be donned in all cases, and the use shall include any time a firefighter is subject to hazardous, toxic smoke environment. Section 103.3, the pass device. When these were written years ago, pass devices were not a part of our SCBA. Since these revisions, we have a new Scott Air Pack system. When you now turn on your SCBA, the pass device operates. Protective clothing and response guidelines. Prior to leaving the station, everyone should be wearing their PPE or bunkered, excluding officers. Any passengers riding in the cab or jump seat area. In all cases, the use of seat belts will be enforced. No equipment shall leave the station without members being properly belted. Fire helmets shall have the radio number on the helmet, rank, and district logo. Either leather or decal can be applied to the helmet front as the rank on the badge. Fire helmets shall be worn by all members of the district at all times while attending any fire or emergency incident, unless excused by an officer. If a personal helmet is used, it must be approved by the fire chief. Any gear must be approved by the fire chief before worn on our scenes. All members shall be required to wear protective clothing while performing duties at an incident involving fire or any substance which could cause injury to members involved unless excused by the officer. Members shall provide themselves with such clothing as is necessary for wearing beneath their protective clothing to prevent injury in themselves during periods of cold weather. Items of protecting clothing, other than those issued by the district, may be worn only with the approval of the fire chief. The district shall provide helmet, bunker coat, bunker pants, bunker boots, gloves, and protective hood. Personal appearance and hygiene. Eccentric style of methods of grooming scalp and facial hair should not be permitted. Violation of hair or beard policies by any member shall make him or her subject to disciplinary action. The wearing of head jewelry or head adornments while in or around the station quarters or public demonstrations while in uniform will be strictly prohibited. All members shall be required to keep their person in a clean and hygienic condition. The failure of any member to abide by this rule shall constitute a health hazard to other members of the district, and as such shall make the offending member subject to disciplinary action. Any member who persists in following unsanitary habits while performing duties on behalf of the district or does not attempt to correct such habits which causes discomfort of other members of the district shall be subject to disciplinary action. Hair code for males. Hair shall be neat, clean, trimmed to present a groomed appearance. It shall not be of such length that it interferes in the normal wearing of all standard equipment and headgear. Hair shall not fall below the earlobe. Hair on the back of the head shall not fall below the button of the shirt collar when standing with the head in a normal posture. The wearing of wig or hairpiece by male personnel while on duty is prohibited, except to cover natural baldness or physical disfigurement caused by a medical procedure or accident. A hairpiece when worn shall conform to the standard haircut criteria. The face shall be clean shaven, except that his neatly trimmed mustache is permissible. If worn, mustaches shall be permitted to extend 1/2 inch sideways at the corner of the mouth, 1/2 inch below the corners of the mouth. Fu Manchu mustaches, beards, goatees, mutton chops, and other eccentric styles of facial hair are prohibited. Sideburns shall not be flared or any wider at the bottom than the nature width of the top. Hair code for females. Hair shall be neat and clean and present a groomed appearance. Female firefighters shall wear a style and length that does not excessively brushed out from under a fire helmet or a uniform cap. Hair may be tied in a bun or pinned up. Section 104-1, Disciplinary Action Policy. Preventative action standards for accessible and appropriate conduct will be established by management and made accessible to all employees. Employees will know not only what is expected in terms of conduct, but also what course of action may be pursued in case standards of conduct are not met. Corrective actions 1. Corrective action except for severe or extraordinary case of misconduct, calling for immediate discharge, will be the progression in nature. The object of disciplinary action is to correct or modify behavior or to prevent reoccurrence of inappropriate conduct through positive, confidential counseling of the employee. 2. In cases where an employee feels that corrective action is inappropriate or unfair, the supervisor will take the initiative in advising the employee to channel his or her complaint through the department's formal grievance procedure. If after a designated period of time, as explained in Section G of this policy, the employee shows no further evidence of misconduct, his or her prior history of violation will not be considered in matters relating to wage increase, promotions, transfers, leave of absence, and future employment references. C. Definition of corrective action. The corrective actions which may be taken progressively in their order of severity are as follows: a written warning, a formal discussion of the nature of the misconduct of the employee. That repetition of the misconduct will lead to progressively more severe correction action. Documentation of this discussion is required for inclusion in division records and the original in the employee permanent personnel file. A written reprimand. An infraction of departmental policy and procedures will be handled on the progressive disciplinary record, to be initiated and filled out completely at the supervisory level involved. When this form is made out, it shall be represented to the next higher level of supervision for review. Addition and or corrections may be necessary to coordinate proper corrective action to be taken. It should then be shown to the employee involved. Employee has 48 hours to respond by written appeal to a hearing board before it goes to his or her personnel file. The employee is requested to sign in form to be given the opportunity to make a statement to the space provided, if he or she so desires, before it is forwarded to his or her permanent personal file. If the employee refuses to sign the form, the supervisor should write this information on the form and have it witnessed. C. Suspension. In order to the employee to absent him or herself from work without pay for a specific time period, usually 1 to 10 consecutive scheduled working days, or in the case of volunteers, up to 60 days. Documentation will specify the nature of the misconduct, times, plateness, witnesses, and if any, the preventive disciplinary actions taken. The employee is requested to sign the documentation to indicate that he or she is aware of the nature of the misconduct, and similar misconduct will result in termination. Prior to suspension of an employee, the respective supervisor shall consult with the chief. An employee may be suspended while an investigation of alleged violations of policy or procedure or Category 1 is in progress. D. Discharge. An involuntary termination of employment. Documentation will specify the nature of the misconduct, time, places, witnesses, if any, and previous disciplinary actions taken. Prior to discharge, the supervisor shall consult with his or her immediate supervisor and chief of the department. The employee may appeal to the board of directors if he or she decides the action against him or her is inappropriate. D. Examples of misconduct. Examples of misconduct for which an employee may be disciplined and or discharged are separated into 4 categories with appropriate disciplinary measurements indicated for each category. These examples are for illustration of the seriousness of offenses and the category in which the examples will be considered, but are not all inclusive of misconduct. Offenses of misconduct will be considered on their individual merits, and the district shall assign category of action after careful consideration and deliberation. Category 1, discharge upon first offense, conviction of a felony, willful violation of safety regulations, theft of CCFPD property, fellow workers' property, or property relative to fire department call, scene operation. Insubordination, falsifying any official CCFPD records, immoral or lewd conduct on fire department calls or scenes, malicious or deliberate abuse of fire department or call scene property, unauthorized possession of firearms or weapons on department property, intoxication of alcohol or illegal drugs while on duty, possession of illegal drugs on department property, loss of operator's license. Category 2, 1, suspension, 2, discharge. Reporting for duty under the influence of alcohol or illegal drugs. Disorderly conduct, fighting, or inciting a fight on department property or call or scene property. Refusal to accept work assigned by supervisors to take directions from an individual assigned to be the supervisor. Dishonesty, misrepresentation, or making a false statement, vending, soliciting, or conducting business on department property without fire department authorization. Category 3, 1, written reprimand, 2, suspension, 3, discharge. Revealing confidential information, malicious practical joking or horseplay. Conduct prejudicial to the best interests of the department. Soliciting or accepting cash gifts or gifts of any kind from anyone in relation to department operations. Category 4, 1, written warning, 2, written reprimand, 3, suspension, 4, discharge. Inefficient or careless job performance, poor productivity. Failure to observe safety or hygienic rules. Smoking or chewing in unauthorized areas. Improper attire or appearance. Unexcused tardiness, unexcused absences. Section E, additional corrective action for multiple violations. 1, action calling for disciplinary suspension within 1 year dating form. First suspension may result in discharge. Acting calling for a written reprimand while reports of 2 previous written reprimands or 1 previous written reprimand and 1 suspension are still active in an employee's record may result in a discharge. Section F, documentation of corrective action. Documentation of written reprimands, suspensions, and discharges must be made to the administration for filing to the individual's permanent personal file. Written reprimands require only the signature of the reporting officer, the chief, and the employee, him or herself. Suspension requires the signature of the fire chief or designated officer and the employee. Discharge requires the signature of the fire chief and or designated officer and the employee. The refusal of an employee to sign such documents does not stop the process of the form. The presence or absence of an employee's signature does not imply, nor will it construe to mean that the employee disagrees or agrees with the action taken. In cases where the employee is unable to or unwilling to sign the form, the fact should be noted in the block reserved for the employee's signature in order to document the fact that the corrective action has been discussed with the employee. Once all appropriate signatures are obtained, 1 copy of such will be given to the employee and another will be retained in the individual's permanent personnel file. G, record keeping. Records of violations of rules or policies listed in Category 1 shall become a permanent part of the employee's record. Records of violations of rules or policies listed in Categories 2, 3 shall remain active with the employee's personnel record for 1 year, after which records of the violation will be considered in matters relating to will not be considered to matters in relating to wage increase, promotions, transfers, leaves of absence, and future employment references. Records of violations of rules or policy listed in Category 4 shall remain active in the employee personnel record for 6 months prior dating from the last violation. If no further violations occur within 6-month period, then records of violation will not be considered in matters relating to wage, promotions, transfers, leave of absence, or future employment references. H. Closing clause. In any of the aforementioned proceedings, the employee may have legal counsel to represent him or her in any stage. Nothing contained herein shall prevent the employee from representing him or herself. (104-2) Substance Abuse Policy. The CCFPD realizes the importance of providing a safe and healthy workplace. The district also realizes the dangerous effects of alcohol and drug abuse on safety, work quality, increased medical expenses, and low productivity. Accordingly, we have adopted the following policy with respect to employee involvement with alcohol, illegal drugs, and/or controlled substances, as defined under state and federal law. As a condition of employment, each employee shall abide by this policy. Prohibited activities. The following activities are prohibited: reporting to work, returning to work, or being at work while under the influence of alcohol, illegal drugs, or other controlled substances, or being impaired in performing work because of alcohol, illegal drugs, or controlled substances. Any employee who engages in any of the above prohibited activities will be subject to termination of employment. Prescription, over-the-counter, and registered medication. It is the responsibility of the employee to inform his or her immediate supervisor when taking medication, prescribed or over-the-counter, that may impair work performance. In the medication will impair his or her work performance, the employee will be sent home until he or she is no longer under the influence of the medication, and the absence will be treated as sick or medical leave. For purposes of a violation of this policy, illegal drugs include drugs used in excess of the dosage prescribed or registered to one making the distribution of dispensing, and also include the possession or sue by one other than the individual to whom the drug was prescribed or registered. Administration of the policy. Anytime the chief or board requires physicals, the district may require the employee to provide a blood and/or urine specimen for testing and complete a written consent from the such testing. If the district has reason to suspect any employee of engaging in prohibited activities, then the district may require the employee to provide a blood or urine specimen for testing and complete a written consent form for such testing. The employee's refusal to comply will constitute insubordination and will be grounds for termination of employment. The collection and testing will be in a manner to reasonably provide confidential and chain of custody. The employee may be suspended during the investigation stage. Such suspension is without pay, but subject to pay for lost time if test results or investigation is negative. Every reasonable effort will be made to complete the investigation within 120 hours. How CCFPD handles positive test results. Every blood specimen submitted will be tested to determine the presence of alcohol to a degree of mg due or greater. Every urine specimen submitted will be first tested with a screening procedure to determine the presence of drugs or other controlled substances. Positive screening results are then followed up with a confirmation test. The confirmation test that will be conducted is a gas chromatology mass spectrometry procedure or equivalent. All results which test positive or both the screening and confirmation tests will be ordinarily be returned to the chief's office within 120 hours of the testing. In the case where the alcohol test or drug or substance test are positive, the employee will be subject to termination of employment. How CCFPD handles negative results. When the chief receives a negative test results on a tested employee, the employee and the employee's supervisor will be advised confidentially. The employee will be advised, regardless of the negative test result, that if the district again has reasons to suspect engaging in prohibited activities it may result in the employee again being tested. Confidentiality. All information obtained in the course of testing of employees shall be protected as confidential medical information. No data concerning participation in any rehabilitation program will be part of the employee's personal file, nor will it be provided to any other party without written consent of the employee or pursuant to lawful subpoena. Voluntary treatment for employees. Any employee who feels that he or she has developed an addiction or dependence upon or problem with alcohol, drugs, or other controlled substances is encouraged to seek help through the Employees Assistance Program or through their own personal health coverage. Employees who seek help through the EAP or their personal health coverage can do so without reprisal, job jeopardy, or disciplinary action, provided the following conditions are met. 1. Notify your immediate supervisor and other member of chain of command before violation of the policy occurs. Either through the EAP or your health provider, a rehabilitation program will be found for the employee to begin immediately. Where the EAP is not consulted, the employee's personal health coverage will be used to cover expenses. Where a violation in policy has occurred, an employee request to submit to rehabilitation program will not serve to waive the application of disciplinary action, except in extraordinary circumstances. Participation in a rehabilitation program is confidential. Employees will be encouraged to sign a release of information statement, so management will be aware of an as-needed basis that the employee is seeking help. The district reserves the right to have the employee subject to unscheduled testing during the 60 months following completion of a rehabilitation program. Voluntary referral to a rehabilitation program does not exempt the employee from future substance testing or disciplinary action under this policy for future prohibited activities. An employee is allowed to be rehabilitated only once during their employment at this department. Application of policies to applicants. The district will not employ those applicants for employments who are shown to be abusers of alcohol, illegal drugs, or other controlled substances. Accordingly, any employment offered to an applicant is conditioned on the following. The applicant within 48 hours must provide a blood and/or urine specimen for testing and complete a written consent form for such testing. If the presence of alcohol to agree, which would otherwise constitute a prohibited activity under paragraph 2, illegal drugs or other controlled substances is established, the applicant will no longer be considered for offered position. Searches. The district reserves the right to conduct searches of all department property, including vehicles, desks, and storage areas of employee personal property. The district also reserves the right, if it has reason to suspect an employee or applicant of engaging in prohibited activities, to require the employee or applicant to submit to a search of the employee or applicant or the employee or applicant's personal property or vehicle on district's premises. The employee's refusal to comply will constitute insubordination and will be grounds for termination of employment. The application's refusal to comply will terminate consideration of employment. Notification of conviction. As a condition of employment, each employee will notify in written to the district of any criminal, alcohol, or drug statute violation no later than 5 days after such conviction. Within 30 days after receiving such notice of such conviction, the district will take appropriate action, which will make the employee subject to termination of employment. Discipline of an employee under this policy will be subject to the district's disciplinary code. If you have any questions regarding anything within this policy, please consult the fire chief's office. (104-03) Promotions and demotions. While the policy of the district prefers every effort will be made to promote to the higher ranks from lower ranks already within the staff, the fire chief may promote or demote any member of the staff as he or she may deem appropriate, according to the best interests of the district. However, the fire chief shall promptly inform the board of directors of his or her action at the next regular board of directors meeting. Moreover, in case of paid employment, the fire chief shall not promote any paid officer to a higher rank carrying a higher salary unless such higher rank and higher salary are provided for in the then current budget of the fire district. Moreover, the fire chief shall make promotions only after appropriate examination and rating of experience and other matters to be according to the usual operating policies of the district. The chief may demote members of the staff to a lower rank whenever this will serve the best interest of the district, or whenever the results from the demonstrated inefficiency or incompetence of the individual to carry their rank, or whenever necessary for disciplinary action. Every demotion shall be reported in writing to the Board of Directors by the fire chief, and a copy of such written report shall be included within the personal record of the individual affected. Violations of Chain of Command, Sections 104-04. Any member of the Cole County Fire Protection District or staff who, through the determination of the fire chief, has willfully violated the chain of command and proceeded to an officer of higher rank than his or her immediate supervisor with a matter concerning district policy, rules, and regulations, or decisions made by his or her immediate supervisor without first contacting his or her immediate supervisor, may be subject to disciplinary action for a period of time determined by the fire chief, or may be discharged. Any member of the staff who willfully proceeds past the chain of command and contacts any member of the Board of Directors or any news media with a matter concerning district policy, rules, and regulations, a decision made by any superior officer or district business, without first consulting each step in the chain of command, may be discharged by the fire chief. This policy is not to be construed to mean that any staff member will not talk socially to any officer or any member of the Board of Directors or any member of the news media, as long as a staff member does not initiate conversation pertaining to district policy, rules, and regulations, or decisions made by the district officers or any member of the Board of Directors. Any member of the staff will not engage in conversation with any member of the news media concerning matters of district policy, rules, and regulations, or decisions made by the district officers or any member of the Board of Directors unless that staff member has, through the chain of command, obtained permission from the fire chief. Any member of the staff of the Cole County Fire Protection District may proceed past his or her immediate supervisor when his or her immediate supervisor is not available. The staff member will then proceed to the next step in the chain of command. Section 104.5, Formal Grievance Procedure. Purposes: procedures for handling grievances other than those relating to discharge or reduction in rank or compensation. Whenever a member have a grievance relating to this membership employment with the department, he or she shall first present it in a written form to his or her superior. It shall be the responsibility of the supervisor to arrange a resolution of the matter as quickly as possible within the discretion permitted to him or her. The supervisor shall either conclude settlement of the grievance or advise the member employee of his or her rights to present the matter to the next higher ranking authority. If the member employee then wishes to present the matter to a higher authority, he or she may do so in written form in the following manner. Prepare the grievance in writing. Submit one copy to his or her superior officers and one copy to the fire chief. The superior officer in this case may then, at his or her discretion, review the matter and render a decision or turn it over to the fire chief. In the event the decision rendered by the chief does not resolve the matter, the aggrieved member employee may submit in writing through the chief a notification to the Board of Directors, who may consider the matter. Purpose: proceeding for handling, discharging, reduction in rank, and reduction in compensation. Any person who is discharged or reduced in rank or compensation may appeal in writing to the Board of Directors within 5 days after the effective date. Upon such appeal, both the appealing member employee and the chief shall have the right to be heard and to present evidence. At the hearing of such appeals, technical rules of evidence shall apply. After hearing and consideration of the evidence, the Board of Directors shall render a decision that will: 1. Confirm the discharge or reduction in rank or compensation. 2. Reinstate the member or employee. 3. Provide for such disposition as it deems necessary or appropriate. Those in attendance at the hearing may include, but not limited to, the following people. 1. The Board of Directors shall review and weigh the evidence presented. 2. A representative may present the evidence on behalf of the aggrieved member or employee. And 3. A representative who may represent and present the evidence on behalf of the fire chief.